ICE just released official 2025 deportation statistics, and the big story is not a single headline number, it's the pattern. The data suggests interior arrests are up, detention is at record levels, and fewer people are being released while their cases are still pending. If you or someone in your family is undocumented, in removal proceedings, has a prior order, or even just has contact with the system through a check-in, a court date, or a local arrest, this matters. Because when detention goes up and releases go down, the entire pressure of the system changes fast. By the end of this video, you will understand three things. First, what these ICE numbers actually measure in plain English. Second, who is most affected versus who is usually less affected, including the edge cases that trip people up. And third, a practical checklist of what to do now and what to avoid so you do not accidentally make a situation worse. Here is the part most people miss. A lot of viral posts talk about deportations like it is one single pipeline, but ICE data usually separates different stages. You typically see numbers around arrests, detention, or custody, and removals. Those are related, but they are not the same thing, and a shift in one can change your risk even if the total removals number does not move the way people expect. So let's slow down and define the terms in normal English. When ICE talks about arrests, they usually mean an ICE enforcement arrest. That can happen inside the United States, often called interior arrests, as opposed to an arrest that happens right near the border. When ICE talks about detention, they mean people being held in ICE custody in detention facilities, sometimes through contracts with local jails or private facilities, depending on location. When ICE talks about removals, they mean people actually being physically removed from the United States under an order of removal or other removal process. Another number you may see in data sets is releases, like releases on recognizance, releases under supervision, or releases due to capacity, medical issues, or court decisions. So if the input data says detention is at record levels and fewer people are being released while their cases are pending, that points to a system that is holding more people during the process instead of letting them fight their case from the outside. And that changes everything. Access to lawyers, ability to gather documents, ability to keep a job, and the speed at which cases move. Now, what changed in 2025, based on what is being reported from ICE's own statistics in this idea brief? 3 trends. Interior arrests up, detention up to record levels, and fewer releases pending case outcomes. I am going to be careful with wording here. I am not going to invent exact numbers or claim specific categories unless you can verify them directly in the ICE release. But the direction matters, because direction tells you what kind of environment we are in right now. If interior arrests are rising, that can mean more enforcement activity away from the border. If detention is rising, it can mean more people are being held longer, or capacity is being used more aggressively, or both. And if fewer people are being released while cases are pending, that can mean more people are spending the entire court timeline in custody. And the court timeline can be long. This is where people get blindsided because they assume removal proceedings are just court dates spaced out. But when you are detained, the reality is different. Detained dockets can move faster, but access to counsel and evidence can be harder. So you need a different plan. Now let's talk about who is affected versus who is not, because this is where panic spreads when it should not. If you are in one of these buckets, you should pay closer attention to the trend and consider getting advice early from a qualified immigration attorney or accredited representative. Bucket 1. People with a final order of removal, especially if there has been recent contact with ICE, a prior check-in history, or a past removal that was not executed. Even if you have been living quietly, if there is an existing order in the system, a change toward more interior enforcement can raise practical risk. Bucket 2. People currently in removal proceedings in immigration court, especially if you have missed a hearing in the past, have a prior in absentia order, or have had address problems. Here is the small detail that changes everything. Notices and hearing dates are often mailed. If your address is not updated properly in the correct system, you can miss something and end up with an order without realizing it. Bucket 3. People with recent or repeated contact with local law enforcement, even for low-level issues. In many places, local arrests can create a handoff moment, like a detainer request or notification, depending on local policies. I am not saying this happens everywhere the same way, and policies vary by city and county, but the data trend of rising interior arrests often overlaps with more arrests that start as local contacts. Bucket 4. People who are on ICE supervision, including people doing check-ins, wearing GPS monitors, or in programs that require reporting. If the trend in the data is fewer releases pending cases, it suggests a tighter posture around custody decisions. That does not mean every check-in turns into detention, but it does mean you should treat check-ins and any communication with the agency as high-stakes moments where preparation matters. Bucket 5. People who think they are safe because they have an application pending, like an asylum application, family petition, or other process. This is a major confusion point. Having something pending does not always equal protection from enforcement. Sometimes it helps. Sometimes it does not. It depends on your status, your procedural posture, and your specific facts. This is why accurate advice early matters. Now, who is generally less affected by interior enforcement trends? People who are U.S. citizens, obviously. People who are lawful permanent residents, in many cases, are less likely to be swept into enforcement actions, but there are important exceptions, especially if someone has certain criminal convictions or is accused of fraud. Also, people who have a valid non-immigrant status and are maintaining it are usually not the target of interior deportation activity. But again, there are exceptions if status has lapsed, if there are violations, or if there are allegations of misrepresentation. Here is another group that often gets confused: mixed status families. If one person is out of status and another person is a U.S. citizen or green card holder, the U.S. citizen does not become deportable, but they can still be impacted in very real ways through family separation, caregiving disruption, and financial stress. That is why family planning is part of a risk reduction strategy, even when not everyone is directly at legal risk. Myth versus reality moment number 1. Myth: if ICE deportation numbers rise, that means everyone is being deported. Reality: the system runs on categories and priorities, and the biggest risk is concentrated in specific procedural situations, existing orders, custody situations, and certain local contact pathways. The second myth: if you have a court case pending, ICE cannot detain you. Reality: many people fight cases while detained. Detention is a custody decision layered on top of the court process. It is not the same as the final outcome. The third myth: if you stay quiet and do not travel, nothing can happen. Reality: interior enforcement actions can be triggered by records, prior orders, check-ins, and local law enforcement contact. Staying quiet can reduce exposure, but it is not a guarantee. Now the natural question is why this is happening, and I want to keep this non-political and process-focused, because the brief you gave is specifically based on ICE's own data, not opinions. There are a few non-exclusive explanations for why you can see interior arrests rise and detention hit record levels. One is resource allocation and operational focus. If more agents and teams are focused on interior operations, you will see that show up in interior arrest numbers. Another is coordination with other agencies and data systems. Enforcement is not only a person knocking on a door, it can be record-based, databases, warrants, prior orders, and identification after arrests. A third factor is detention capacity and management. If capacity increases, or if the agency uses more of its capacity, you can see record detention numbers. And here is a backlog mechanic that matters. When immigration court backlogs are high, cases take longer, and if fewer people are being released pending their cases, the average time someone might spend in custody can increase, even if removals do not increase proportionally. Another factor is policy guidance and risk tolerance. Agencies can tighten or loosen release criteria, supervision standards, and how they interpret flight risk or public safety risk. I am not claiming any specific new memo unless you can point to it in the official release, but operational posture can shift within existing authorities. This is where people get denied bond or delayed release, because small factors like missed check-ins, unstable address history, or lack of documentation can be interpreted as higher risk. Now let's translate these trends into real-world consequences, because this is not just numbers. Consequence 1. More people may be detained during the process instead of being released to wait for court. If you are detained, it becomes much harder to find counsel quickly, gather evidence, and maintain your job. It also affects family stability. Consequence 2. If detention is near capacity, transfers can happen. People can be moved to facilities far from home, which makes visits and legal preparation harder. Consequence 3. If fewer people are being released, bond outcomes and alternatives to detention become even more important and may become more contested, depending on your facts and location. Consequence 4. The timeline of your case may change. Detained cases can move faster. That can be good if you have a strong case and a prepared lawyer. It can be dangerous if you are not prepared and do not have documents lined up. Consequence 5. Fear and misinformation spike. People start making sudden decisions like skipping court, changing addresses without updating the court, or relying on advice from social media. Those choices can close doors. Here is an example scenario to make this concrete. Example scenario 1. A person is pulled over for a broken taillight. The local jurisdiction books them, fingerprints are taken, and the person is flagged because of an old immigration issue from years ago. Depending on local policies and the person's history, ICE becomes aware and may try to assume custody. The person is shocked because they were not doing anything serious. The real lesson is not that traffic stops always lead to ICE. The lesson is that local contact can become a trigger point when there is already something in the system, like a prior order, missed hearing, or prior encounter. Example scenario 2. A person has been doing regular ICE check-ins for years while their case is pending or while they are under supervision after an order. They show up for a scheduled check-in expecting the same routine. But the agency posture is tighter, detention beds are available, and the officer decides to detain based on risk factors or new instructions. This does not happen to everyone, but it happens enough that you should treat check-ins as important events. That means you should not go alone if you can bring counsel. You should have key documents, and you should have a family plan in place. Now let's shift to what to do now, because this is the part you can control. I am not giving legal advice here, but I can give you a safe planning checklist that reduces avoidable risk and helps you get accurate information faster. Do this. Confirm what your current status actually is. If you have ever been in immigration court, find out your next hearing date and location through official channels. Keep proof of your address updates. If you move, update your address where required and keep copies. Do this. If you have a pending case or prior order, talk to a qualified immigration attorney early, not after a detention happens. Early advice can help you understand whether you might have options like reopening, stays, relief, or procedural steps. Even if the answer is that options are limited, knowing early changes how you plan. Do this. Build a family preparedness plan. That includes emergency contacts, childcare pickup permissions, where important documents are stored, and a plan for bills and rent. Keep copies of key documents in a safe place and with a trusted person. Do this. Document your equities and ties. Again, not legal advice, but generally speaking, stable residence, family ties, work history, and community ties can matter in many contexts. Keep records organized. Pay stubs, lease, tax records, school letters, medical documentation if relevant. Do this. If you have check-ins or court dates, plan them like critical appointments. Arrive early. Bring identification and any required paperwork. If you have counsel, coordinate. If you do not have counsel, consider getting at least a consultation beforehand to understand risks and what to bring. Now avoid this. Do not skip immigration court. Missing court is one of the fastest ways people end up with an order they did not expect. Avoid this. Do not rely on a friend of a friend for legal strategy. and do not take irreversible steps based on a viral post. If you hear a claim like, ICE is deporting everyone now, or there is a secret new list, treat that as unverified until you see it in official sources or credible reporting. Avoid this. Do not carry fake documents or use false identity documents. That can create additional legal problems and can reduce options later. Avoid this. Do not sign documents you do not understand, especially under pressure. If you are detained, ask for time to review and for legal help. Avoid this. Do not assume that having a pending application automatically stops enforcement. It might help in some situations, but it is not a universal shield. Myth versus reality moment number 2. Myth. Record detention means deportations will automatically skyrocket. Reality. Detention can rise because of custody posture and case processing dynamics, and removals can be constrained by court timelines, travel document logistics, and legal processes. The key point is that detention increases the stakes for the person involved, even if the national removal total is not what social media assumes. Myth versus reality moment number 3. Myth. If you do not have a criminal record, you cannot be detained. Reality. Many people without criminal convictions still end up in detention due to orders, status issues, or procedural factors. Criminal history can increase risk, but it is not the only variable. Now let's talk about what to watch next, because these numbers are a snapshot and the environment can change quickly. Watch point 1. Any new public guidance about enforcement priorities, detention criteria, or prosecutorial discretion. Guidance can come through official statements, fact sheets, or policy documents. Watch point 2. Detention capacity and contracts. If capacity expands or shifts geographically, you may see more transfers and changes in where people are held. Watch point 3. Immigration court capacity and scheduling. If detained dockets are prioritized, that can speed timelines and increase the need for rapid legal preparation. Watch point 4. State and local cooperation trends. Some jurisdictions change how they handle detainers or notifications. This is local and can change with local leadership and litigation. Watch point 5. Litigation and court decisions. Court rulings can affect detention standards, bond eligibility interpretations, and procedural rights. That can change risk quickly, sometimes within a specific circuit or region. Here is the part most people overlook. The safest way to respond to shifting enforcement is not to guess national politics day to day. It is to tighten your personal information, your documentation, and your plan so you are not scrambling if something changes. Now a quick verification segment, because you should always anchor in reliable sources. If you are looking at ICE data, confirm you are reading the official release or a direct link from ICE or DHS, not a screenshot. If a claim is made about a specific number, look for the table and the definitions. Sometimes, one dataset counts encounters, another counts individuals, and another counts events. Also check the time frame. Fiscal year versus calendar year can change what people think they are seeing. If you are dealing with a personal case, use official case tools where applicable and consult a qualified immigration attorney for your exact situation. Now let me recap in 5 calm points. 1. ICE's official 2025 statistics, as described here, suggest a shift toward more interior arrests, record detention, and fewer releases while cases are pending. And if you want, leave a comment with your general category, like pending court case, check-ins, mixed status family, student, or employer, and I will cover the most common questions in a follow-up video.